Okay.
Wonderful. Okay. So yeah, welcome everyone. We've got 34 participants so far, which is great, and that number's going up. I'm just going to give a quick acknowledgement of country. I'm on Gumbaynggirr land up in Coffs Harbour, and I pay my respects to the traditional owners, the custodians of the land and waters of the whole of New South Wales, and all the Aboriginal elders, past, present, and emerging. For those who didn't hear me before, it would just be great if a few of you would like to say who you are, where you're from, if there's something that you're particularly interested in tonight. Maybe you're interested in learning about biodiversity conservation law when it comes to the land or the sea, or something local in your backyard. So we're going to be hearing from Jemilah Hallinan tonight. She is an environmental lawyer and she's the head of legal education at the Environmental Defender's Office. We're really lucky to have her to be able to help us to learn about biodiversity conservation laws here in New South Wales and how we can navigate the system. I know as a campaigner here at the National Parks Association, I do get asked many questions. Oh, apparently the chat's disabled. Sam, I don't know if you're able to help. Somebody just...
Yep, I'll fix that up.
Oh,
bear with me.
Wonderful. So yes, I've had quite a number of people ask me since I started with the National Parks Association in regards to how to get a campaign started or how to advance a campaign. And for us to be able, for a campaign to be effective, obviously we need to first be able to understand our biodiversity conservation laws in New South Wales and how we can affect change. Is the chat working yet?
Not yet, hang on.
Yeah.
Just give it a couple of minutes.
Yeah, no worries. Wonderful. So, Jem, you may get a few people.
It's on now.
Okay, wonderful. It's on. So again, we encourage everyone to just put into the chat your name, where you're from, is there a particular campaign or local issue that you're interested in, or a particular area of the biodiversity conservation law system here in New South Wales. So anyway, coming back to Jem. So Jem, would love you to share with us tonight a little bit about the system here in New South Wales, maybe some of the key legislation, including the Biodiversity Act, the National Parks and Wildlife Act, the Native Vegetation Laws, the EPBC Act, anything that you think that might help MPA members to be able to campaign for nature in their backyard. So over to you, Jem. Thanks so much for coming.
Thanks, Danielle. Thanks, Sam. It's really nice to be here. I'm coming to you from Gadigal land in Sydney. Pay my respects to their elders, past, present, and emerging. So I've been asked to sort of give you a high-level overview of the laws that relate to biodiversity. There's a fair few of them, so I'll go through them in turn. Sam's going to drive me through this presentation, so I'll just be telling her when we're going to move through. In a couple of weeks, we're going to do another webinar on some key skills that you'll need in order to engage effectively with these laws, particularly around submission writing. So you'll hear me mention submissions a lot tonight. And if you don't know how to write a submission or you just want to update your skills in that area, I will take you through some key tips in submission writing in the next webinar. So other than that, I'm happy to answer any questions that you might have if you put them into the Q&A function towards the bottom of your screens. I'll answer whatever I can, but this is a huge topic, lots of law, so I'll do my best, but there might be things I have to take on notice. Next slide, please, Sam. This is just a disclaimer. It's the lawyer in me coming out that the information provided tonight is just that. It's information and not advice. It's all being checked, and as far as I know, it's legally accurate to the best of my knowledge. But EDO doesn't accept any responsibility for loss or damage resulting from it. Next slide, please, Sam. So environmental matters largely regulated by state laws. But I'm going to begin tonight by giving you an overview of the main federal environmental law that regulates biodiversity, and that's called the Environment Protection and Biodiversity Conservation Act, which we call the EPBC Act. So I'm going to focus on where that act offers opportunities for the public to get involved in the processes and decisions that it provides for in order to get better outcomes for biodiversity. Then I'm going to take you through 3 of the major state environmental laws affecting biodiversity. Again, I'm going to focus on the opportunities for public involvement. Like I mentioned, these laws are really complex. They do overlap to some extent. So I won't touch on every aspect of these laws because that would take all night. We do have fact sheets on our website at the EDO that cover a lot of these matters off. So have a check out the Environmental Defenders Office website if you want to follow up on some of the information that we're covering. And you can just find our fact sheets by searching for legal resources on our page. Oh, and I should say for those of you who don't know that the EDO is a community legal centre. We're a national CLC and we specialise in public interest environmental law. Next slide, please, Sam. So we're going to begin with the EPBC Act. Next slide. So in a nutshell, the EPBC Act aims to regulate nationally important plants, animals, ecosystems, and heritage. And these are defined in the Act as matters of national environmental significance. And it regulates these by doing things like requiring federal government assessment and approval of projects that will significantly affect those matters of national environmental significance. It provides for listing of threatened species and ecological communities. It allows for the declaration and management of protected areas, so World Heritage, National Heritage, Commonwealth Heritage, Ramsar sites, which are important wetlands. And it allows for the declaration and management of Commonwealth marine parks. It also requires a 5-yearly State of the Environment report. Next slide. So we're dealing here with matters of national environmental significance. So they're known as triggers colloquially because these things trigger the operation of the EPBC Act, okay? So when we're talking about triggers or matters of national environmental significance, we're talking about World Heritage properties, national heritage places, Ramsar wetlands, which are, as I said, wetlands of international importance, nationally listed threatened species and ecological communities, migratory species, Commonwealth marine areas, the Great Barrier Reef Marine Park, which is also a Commonwealth marine area, but gets its own head, it's its own trigger. We're talking about nuclear actions, and we're talking about water resources in connection with coal seam gas or major coal mines. So there's quite a few of them there. And most of these are, the law here is implementing international agreements, so treaties and conventions where Australia has an obligation to protect these things. So this is the law that does that, implements Australia's treaty obligations. Next slide, please, Sam. So the EPBC Act empowers the government to assess development projects, and it regulates them as controlled actions, right? So controlled actions are developments or projects that will have or are likely to have a significant impact on a matter of national environmental significance. So one of those triggers I just went through. And if you're unsure about whether or not there's likely to be a significant impact, there are significant impact guidelines the government has published, and they can assist you to figure things out. So it will often require you to figure out, well, what's the matter of national environmental significance that's being impacted? And in terms of figuring out if that's going to be significant, you often need to look at the scale of the project or what's proposed but also the sensitivity of that matter. So if something's critically endangered, it might be more easily impacted than something that's just listed as endangered, for example. So before a project can commence, it must be referred to the Federal Environment Minister, and then it will need approval before it can happen. And this approval happens in conjunction with state approvals. So it's in addition to any state approvals that would be required. And if the federal government says no, then the project can't go ahead. But before the minister can decide, the project needs to be referred. And so a lot of proponents apply the significant impact guideline and decide that there's not going to be a significant impact and don't refer the project. So there is a role here for the community to act as a bit of a watchdog. And that's because although you don't have the right to refer something yourself as a member of the public, you can bring it to the attention of the minister. You can write to the minister directly. She has a call-in power. So if something hasn't been referred to her, and you bring it to her attention, she can call it in. And I might provide you with a template in our next session about what that would look like. So she has power to call things in, so bring it to her attention, you tell her why she should call it in and she can do that. But if you can also bring it to the attention of a state government agency that's also responsible for that project. So it might be the Department of Planning and Environment here, for example, and they can refer it. And you can also write to the proponent. And the proponent, you can say to them, you need to refer this. So once it's been referred, the minister gets to decide whether or not it is a controlled action. In other words, whether or not there's likely to be a significant impact on a federally listed matter. And then they'll have to decide, usually they would then determine, if it is a controlled action, determine, well, how are they going to assess it? But there's actually an assessment bilateral in place between New South Wales and the Commonwealth. And what that means is the Commonwealth government has pretty much endorsed the New South Wales assessment processes. And so they'll rely on the state assessment in order to determine what the impacts will be on the federally, on the matters of national environmental significance, basically. So individuals, when a referral has been received, you can comment on whether you think it's a controlled action. There's tight timeframes. I think we're on the wrong slide, Sam. We need to go back one. 10 days. You get 10 days to comment, 10 business days to comment on whether you think it's a controlled action. And then the minister will look at the state assessment usually and decide whether or not to grant an approval for that development. If you find yourself disagreeing with the minister's decision, for example, the minister might have decided a project won't significantly affect a matter of national environmental significance, so it's not a controlled action, or the minister might approve a controlled action. These decisions are open to challenge, legal challenge. It's called judicial review, but they happen in the federal court. But you'd have to find a legal error with the decision. So it's not about whether the decision was a good decision or a bad decision. It has to be a legally wrong decision in the sense that some legal error has been made. Yeah, so the main power here for communities that I would draw your attention to is just to make sure that projects are being referred. The other option that you can do, other than asking the minister to call it in, is you can report it. If the project's already started and it didn't get referred, you can report it to the compliance branch, because it's unlawful to undertake a controlled action without the appropriate approvals in place. Okay, next slide. So the EPBC Act provides for the federal listing of threatened species and ecological communities, as well as key threatening processes. So we all know what species are. An ecological community is a naturally occurring group of plants and animals and other organisms living in a unique location. And once a species or an ecological community is listed, then the law tends to provide that a conservation advice can be prepared, a recovery plan can be provided to the government, and threat abatement plans can be put in place. So a conservation advice, these are really useful documents, provides information on the key threats, on priority local and regional conservation actions, and any threat abatement actions for that species or ecological community. A recovery plan provides information on research and management actions necessary to stop the decline of and support the recovery of the species or ecological community. And key threatening processes are those that threaten the survival, the abundance, the evolutionary development of species and ecological communities. So once they're listed, threat abatement plans can be prepared for how we're going to stop these threats. So land clearing is a key threatening process, or another one is the loss of climatic habitat caused by anthropogenic emissions of greenhouse gases, so climate change essentially. But not every species or ecological community has a conservation advice or a recovery plan in place. And the government is just way behind on preparing these documents. But if they are there, they're really useful because if a decision is going to affect those species or ecological communities, you can point to those things and say, hey, this goes against your own advice or your recovery plan for this species. So you can nominate species and ecological communities for listing. The minister usually asks for public nominations once a year, and all nominations received will go to the Threatened Species Scientific Committee, who then provide a draft listing advice for the minister, and that the public can comment on that draft listing advice. So you can either nominate or you can comment on nominations that have been received, or both. And the minister will make the final decision about which species and communities get listed. And that includes uplisting. So once you're on the list, you tend to move up the list. It sort of goes from vulnerable through to endangered, to critically endangered. And it's very rare for things to go down. They tend to move up, unfortunately. Next slide, please. So the EPBC Act also regulates how areas of importance are listed and managed, and there are several different lists under the Act. We've only included those that the public can actively contribute to on this slide. So not listed here are World Heritage Properties and Ramsar wetlands because those are nominated by the federal government. But national heritage places can be nominated by the public. And these are areas of outstanding heritage value to the nation, and that can include natural heritage value to the nation. The public can comment on the nominations of others. So you can make your own nomination and comment on the nomination of others. So comment in support. And the Australian Heritage Council reviews all the nominations and provides advice to the minister who makes the final decision about whether to list something. And the same process pretty much happens for Commonwealth heritage places. And those are areas, those are, again, areas of outstanding heritage value, but they're on Commonwealth land or waters. Once something's listed on one of those lists, the National Heritage List or the Commonwealth Heritage List, it needs a management plan. And those, whether or not you can comment on them is a bit iffy, but they often devolve that power to the states, and the states tend to be involved in the management of places within their jurisdiction, and some are co-managed with traditional custodians as well. We also have here Commonwealth marine parks or marine reserves. So these are marine protected areas within Commonwealth waters, and they're the waters that extend from 3 nautical miles out to 200 nautical miles offshore. So they're Commonwealth waters. And your main power here is to comment on the plans of management for the marine park or marine reserve. And they're important. Next slide, please, Sam. So we've got 6 management plans for 62 marine parks. There's 5 marine park networks and one for the Coral Sea. And the Great Barrier Reef is managed by the Great Barrier Reef Marine Park Authority, so it's slightly separate, but it does form part of the broader marine park network. Next slide. And they're broken up into management zones. So this is a summary. You probably can't read it, but so I'll summarize it for you. It's a summary of the activities that are allowed in the various zones of the Temperate East Marine Park network off the coast of New South Wales, Lord Howe Island. And looking at the list of activities, we have waste management, commercial shipping, commercial fishing, commercial aquaculture, commercial media, commercial tourism, recreational fishing, mining, structures and works, research and monitoring, national security and emergency response. So many of these activities are permitted in the reserve and they're not compatible with most people's idea of what a marine protected area would allow. So mining operations, exploration, commercial fishing, commercial aquaculture, that sort of thing. Next slide, please, Sam. So this is a drill down into that management plan, and the areas marked with a star, red star, permit mining so long as the appropriate approvals are in place. And the reason I wanted to show you this is just that because it demonstrates an important point about environmental laws generally, and that is that the devil is in the detail. And although you might think, oh, it's a marine park and it's protected, it really does depend on how that marine park is broken down into zones and what each zone is permitting in terms of activities. So it's better to think of our laws in this respect and nearly every other environmental law as a law that regulates and manages the subject matter as opposed to any way protecting it, because that protection is rarely, if ever, in absolute terms. It's very much just managing the impacts as opposed to preventing them. Next slide. So on this slide, these are just some links that I thought might be helpful. Significant impact guidelines that I mentioned, more information on how to nominate species and ecological communities, and more information on how to nominate heritage places. The heritage place one is really useful. I've used that lots of times in the past, and it's where you'll be notified that they're calling for nominations as well. So it's worth keeping an eye on those things. Next slide. So the other thing the EPBC Act does is it mandates a review of the environment called the State of the Environment Report. We've just had one released. You might have heard about it in the media. So these are pretty comprehensive reports that they assess the changing condition of our natural environment across 12 themes, and they look at air quality, Antarctica, biodiversity, climate, coasts, extreme events, heritage, Indigenous, inland water, land, marine and urban categories of the environment. So it's really designed to help shape policy and action. So it's a pretty important document. I really encourage you to take a look. I've got a link on the slides, and these slides are going to be made available to you. So the key findings of our latest report were pretty dire, unfortunately. Basically, to summarise, the environment is in a rapidly changing climate with unsustainable development and use of resources. The general outlook for our environment is deteriorating. And Tanya Plibersek, our new environment minister, summarised the report by saying that the Australian environment is bad and getting worse, and that she hopes to stop this decline and begin reversing it during her tenure as minister. There's a ton of work to do, obviously, in order to turn things around. I think this report is useful because it's the government's commissioned it. It's part of the EPBC Act, and it has lots of useful information that can support arguments that you might want to make to the government when you're pitching your ideas. So very much worth checking it out. Next slide, please. The other thing to note is that the EPBC Act needs to be reviewed every 10 years. And the most recent review happened in 2019-2020. It's called the Samuel Review. It was pretty scathing of the EPBC Act and its ability to meet its objectives. Its findings were that, the environment has declined and is under increasing threat under the EPBC Act. that it does not enable the Commonwealth to effectively protect and conserve nationally important matters. So they're those matters of national environmental significance. It's too complex and cumbersome, I would agree. I've spent years working with that Act and it confuses me greatly. And it duplicates processes at the state level. Now, Samuel recommended that we just devolve approval powers to the states. We don't support that at the EDO. But lots of other recommendations were made about how to address these failures. And we put in a pretty detailed submission to the review, which includes 83 of our own recommendations, which you might find more useful. So you can check that out by following the QR code. And the government seems to have an appetite for reforming and if not just completely replacing the EPBC Act. But what they actually have planned is yet to be seen. I think they're considering their options at the moment, and we can expect to hear more on this. I don't know, in the future. I don't think they've put a date on it. But if there is EPBC Act reform, it will be important to engage in it because it's a pretty important piece of legislation. So hopefully I've conveyed to you by telling you what it does. But that's all I wanted to say on the EPBC Act at this stage. I mean, they're thinking about adding new triggers. So should climate change be a trigger? Should land clearing be a trigger? That sort of thing. Like, there's lots of ways you could tinker around the edges, or you could scrap it and start again with a new Environment Act. EDO has written heaps on this subject, so you can check out our website for more information. State laws. So this is where the bulk of our environmental and biodiversity laws are. I'm going to go through the four most relevant. They're the National Parks and Wildlife Act, the Biodiversity Conservation Act, the Local Land Services Act, and the Biodiversity Conservation SEP. I'm going to focus on where there's opportunity for you to be involved in decision-making and to take action. So we'll start with National Parks and Wildlife Act. And this one sets out a process for establishing and regulating a whole range of protected areas, such as national parks, state conservation areas, nature reserves, Aboriginal areas, wildlife refuges. And these collectively make up our public reserve system in New South Wales, and they take up about just under 10% of New South Wales land. So what can you do? You can offer your own land or suggest the government acquire some form of private land to include in the public reserve system. And on the next slide, there's a link to take you to the site where you can sort of offer that or nominate an area for inclusion. And once it's declared, an area is declared, a management plan will need to be prepared. And that will cover how biodiversity is to be conserved, how cultural heritage is to be managed, and how people can generally use the area because it's public land and people will generally have access to it. Draft management plans are published on the New South Wales Government website for public comment. So I'm going to give you a link to that as well. And so I mentioned that just under 10% of New South Wales is in the public reserve system. And this is obviously not enough to provide any kind of meaningful biodiversity conservation. It does not meet the requirements to be comprehensive, adequate and representative, or CAR, which is a benchmark for best practice protected areas. Private land conservation offers an opportunity to augment the public reserve system and achieve CAR benchmarks. It can also provide really important connectivity between publicly reserved land and that will allow species to move. And that will become really important as climate change starts to really bite. Private land conservation basically involves a landholder voluntarily agreeing to conserve some or all of their land for biodiversity conservation. They can make that agreement with the government or with an NGO. There's a whole range of options to choose from in New South Wales. And nearly all of these agreements will restrict to some extent what can be done with the land. So some are really tight, others are more open to interpretation. But you'll generally not be able to clear the conserved area, graze livestock there or develop the land in any way. It's so that biodiversity values are protected. Some agreements will also have a management plan attached, and that will require the landholder to undertake active management, so control pests and weeds or things like that, fence off areas to exclude livestock and that sort of thing. So that's how biodiversity values are improved over time, through active management. And in return for all of this, dedicating your land for conservation of biodiversity and doing all of this amazing work on it, landholders can access a range of support, either financial or technical, educational support. It really varies depending on what scheme they're participating in. And these are all sort of tailored to the property. So they're negotiated between the landholder and the provider. Some of these agreements last forever, others last for a set period of time. Obviously, the ones that last forever are better. And we've just held a webinar on this topic with WWF as part of our Defending the Unburnt initiative, and a recording of that webinar, as well as a full written guide to all of your options, is available on our website. And I'm going to provide the link to you on the next slide, please, Sam. So here we have just a guide on how to add land to the public reserve system, plans of management and commenting on those, which is important, and private land conservation, everything you need to know about private land conservation. Next slide. This is just a screenshot of where you comment on plans of management. And I just wanted to point out to you that you use the filter function on the left to look, use the status drop-down box to choose draft open for comment. So that way you can go straight to the ones that are open for public comment. You'll see that there's only one open at the moment, which is for the Gardens of Stone State Conservation Area. But it's a useful little site. I just saw a question if we can share the links again, and we're going to send you the links. We're going to send you the presentation, so you'll have all of the links sent to you. I'll move on to the Biodiversity Conservation Act. As the name suggests, this act is designed to conserve biodiversity. It lists threatened species at the state level, so it's another list of threatened species and ecological communities. It does mirror the EPBC list, but it's its own thing, and they are different. They do differ. And it establishes the biodiversity offset scheme, and that regulates how impacts on biodiversity can be offset. So biodiversity offsetting seems to be the government's key approach to biodiversity management, and it brings together landholders on one hand who generate biodiversity credits by agreeing to conserve and manage their land for biodiversity, but it's through one scheme only, which is a biodiversity stewardship agreement. So not all private conservation contributes to this scheme, just one biodiversity stewardship agreement. So they're generating their credits by agreeing to conserve their land and manage it for biodiversity. And it brings together landholders on one side, developers on the other. Developers need those credits to offset their impacts on biodiversity. So the two come together and the landholder sells the developer their credits. Landholder wins because they get money, developer wins because they get to develop and they just have to pay money to offset their impacts. So in New South Wales, all native animals are protected by law, and that includes marine mammals, but not all native plants are protected. There's a list of protected native plants. And protected in this sense means that you need a license to harm or kill the plant or animal. And these are called biodiversity conservation licenses. They're issued by the government, usually to farmers, people who want to deal with pest native animals mainly. You'd be surprised what animals get licensed to be killed. So native plants, animals, and ecological communities that are at risk of extinction receive additional legal protection through the listing process. And the list can apply to individual species, ecological communities, and to some populations of species, but that's quite limited. And then they have their own list of key threatening processes at the state level as well. So you can nominate a species for listing or an ecological community through the New South Wales Government website. And the Threatened Species Scientific Committee will be responsible for determining whether or not the species or ecological community should be listed. And they're an independent committee of 11 scientists. And they also decide whether or not to list key threatening processes. The other key feature of this Act is areas of outstanding biodiversity value. So these are special areas that contain irreplaceable biodiversity values that are important to the whole of New South Wales. And this is this replaces what used to be called critical habitat. You might know it as that, but now it's called an AOBV. And this really underutilised feature of our biodiversity laws. And it's an area where you can nominate areas of outstanding biodiversity value, including over private land. There is a criteria that the government looks at in determining whether or not to declare an area as an AOBV. And once if it has been accepted, the public can comment. You get 4 weeks to comment on nominations as well. So you can nominate and you can comment on nominations. After an area has been declared, the Environment Minister needs to enter into a private conservation agreement, or to try to, with the landholders who are affected. And that will really restrict what can happen in the AOBV area. And look, there's not many, this just hasn't really taken off, but it is something I draw your attention to because it's potentially a powerful tool. And if the minister enters into a private conservation agreement, it won't be a stewardship agreement that's generating credits that can then be bought to offset impacts elsewhere. It will be a pure private conservation agreement that doesn't generate credits for that offsetting scheme. Next slide. So the Act, the Biodiversity Conservation Act, intersects with the Environmental Planning and Assessment Act, which regulates development in New South Wales. And basically, developers need to turn their minds to whether or not their development is likely to significantly affect threatened species. So there's a statutory test. I won't go through it, but it's called the 5-part test. They have to ask themselves a lot of questions, including whether the land they're developing is an area of outstanding biodiversity value. If the answer is yes, then it's going to, it triggers the Biodiversity Conservation Act. And it means that they have to prepare a biodiversity development assessment report, or a BDAR. And that's part of their environmental assessment that they'd have to do anyway, but it's a very specific biodiversity one. The BDAR will be prepared by an accredited assessor, and it identifies the biodiversity values of the land, any impacts that the proposed activity will have, how they're going to avoid or minimise those impacts, and then what's required to offset those that can't be avoided or minimised. So they're applying what's called a BAM, the Biodiversity Assessment Methodology, scientific tool. It's quite objective in that sense. It's not a subjective test, it's an objective test. They're determining what credits would be needed to offset the development. And that BDAR, that report gets submitted with the development application. And then what happens next really depends on the type of development. So I'm going to summarise it at a very high level. If it's just local development, then the consent authority, which would usually be at council level staff, consider the BDAR, and they have to refuse the application, the development application, if the BDAR shows the impacts on biodiversity will be serious and irreversible. They must refuse. So there's a red light there at the local level for certain development. If they do approve the development, they have to require that the credits, that the impacts are offset in line with what the BDAR has specified. So the same credits need to be found. But if it's state significant development, so that's more high impact stuff by its very nature, then the consent authority just has to consider the BDAR, but they don't have to refuse a development if it's likely to have serious and irreversible impacts on biodiversity. So even if it's going to cause a local extinction, they can approve the development, okay? They just need to consider it. They need to approve extinction with their eyes wide open to the fact that that's what they're doing. And if they approve the development, they can require that the developer find the credits that the BDAR specifies, but they can also discount it if there's going to be socioeconomic benefits. They might say, oh, well, instead of getting 5 koala credits, we just require you to get 2, that sort of thing. So our biodiversity conservation law is really based on offsetting the impacts on biodiversity. And unfortunately, the offsetting rules are really very weak and really flexible. So the biodiversity offset scheme says, okay, ideally you'd be going like for like. So you'll either need a species credit or an ecosystem credit or both, depending on what that BDAR says you need. The gold standard is to go like for like. Impact on koala, you need a koala credit. Impact on echidna, you need an echidna credit. Impact on boxgum grassy woodland, same kind of credits, right? But if they can't get like for like, they're allowed to move to variation rules where you go species for species of the same threat status. So if a koala is endangered and you can't find koala credits, you could go for any other endangered animal. So then you're not offsetting koalas, you're just offsetting another threatened species. And the same for an ecological community. And the only point at which that stops is when you get to critically endangered species. You can't move to a different species for when they get to critically endangered, which is on the verge of extinction anyway. So there's nothing to stop a species from declining under these rules. And then, but they don't even need to do that. They can also just pay dollars into a fund, and the Biodiversity Conservation Trust will find those credits. That they'll have the obligation to find the right credits, and that can have benefits because they can then pool all the credits and find some land that's really high quality and just get all of them in one go, one big piece. But you know, it does cause a delay. Impact now, credits might be brought down the track. The other option that they can do is fund conservation research, which isn't offsetting at all. That's just figuring out how much damage has been caused to the species that you also are impacting. And they can, if it's a mine, they can undertake mine site rehabilitation. So they can use future rehabilitation to offset the impacts now. So clear an ecological community, and then they offset it by rehabilitating a mine site 20 years down the track. That counts as an offset. So it's pretty bad actually. But that's what the law allows. So the thing you can do here is you can make submissions on development applications. You can see the BDARs as they come through. And you can also, as I said, nominate an area to be listed as an AOBV. Okay, next slide. That was a bit depressing. Moving on. Helpful links here are how to nominate lists for listings, how to nominate an AOBV, and how to look up development proposals where you can write submissions. Development applications are a key thing you need to comment on because they're a key impact on biodiversity. And offsetting is what you're usually going to see happen to manage those impacts. Next slide. Native Veg, okay, Local Land Services Act. I'm going to have to move quickly now. Manages native vegetation in rural land. So we all know land clearing is a key threat to biodiversity. It's not yet a trigger under the EPBC Act, so it's mainly regulated here at the state level. Now, land clearing rules that apply to a property depend on how the land is mapped. There's a public map called the Native Vegetation Regulatory Map that shows, or is meant to show, how all the land in New South Wales is mapped, so you can figure out what rules apply. but that map is incomplete more than 5 years after the law commenced. A lot of clearing also now happens under codes. The codes set limits and conditions on how clearing can happen. And so long as the landholder complies with those codes, they don't need any approval. Significant clearing does need approval. That is granted by the Native Vegetation Panel. And it has a register of the approvals that it's given, and it usually requires an offset. But other than that, there's no real public registers or anything to show where clearing is happening or how it has been authorised. And that means that most clearing, most of the time, it's going to be impossible to tell if the clearing that you're observing is authorised and lawful. So my advice would be just report it anyway. If it's rural land, it's probably going to be report the clearing to the Department of Environment, because although it's the local land services that regulate clearing, the enforcement goes to the DPE. And I've got some tips here on what you need to include, like who to call, and then what sort of information they need. They have lots of enforcement powers to investigate and take enforcement action. They can issue fines, they can bring a prosecution with big maximum penalties, over $1 million. They also can bring civil enforcement, and the court can make whatever orders it thinks fit to remedy illegal clearing, including just an order to completely remediate the cleared land by replanting. And any person can bring civil enforcement, including you. So I'll explain what that is in a second. Next slide. But in urban areas, it's a lot trickier. Well, it's equally tricky, actually. Public information, again, is super limited. The clearing is regulated by a SEP, or a state environmental planning policy, and it only applies to vegetation that a council has identified in its development control plan, or DCP, as being triggered by the SEP. So the council has to identify the veg, and depending on how it's done that, it might be really narrow in what it applies to, it could be really broad. Or it might not have identified any vegetation, and then clearing is unregulated. And this applies to all urban zones and environmental zones under your LEP. So where the SEP applies, though, it requires a permit from council for clearing that's below a certain threshold, or an approval from the Native Vegetation Panel if it's above a certain threshold. Some clearing is exempt if the veg is dead or dying and not needed as habitat. But it's, again, super hard to determine if clearing that you're observing has been authorised. So it is just better to report it to your local council, and you also have civil enforcement options here. The other thing to keep in mind is bushfire codes. So they can authorise clearing along boundaries and within 10 metres of your home in certain mapped areas, so without any approval whatsoever. So that might have been authorised there. Next slide. Some helpful links: Native Vegetation Regulatory Map, not that that's complete, Native Vegetation Panel, and local land services land management information on the codes as well that apply. Just one last thing, civil enforcement. I've mentioned it a couple of times. Basically, if you see non-compliance, you can report it to the appropriate regulator, the government. They have power to investigate, they have power to enforce, but they often don't, right? Always get a reference number so you can follow up. If they don't, you might be able to take enforcement action yourself. It's known as civil enforcement. It's not aimed at punishing anyone. It's aimed at enforcing compliance with the law. Anyone can bring it, usually before the Lands and Environment Court. And the benefit here is your standard of proof is on the balance of probability. So you have to show it's more likely than not that that person breached the law, which is better than criminal, which is beyond a reasonable doubt. It can be really hard to gather enough evidence to prove that a breach has occurred, because you don't have the right to enter private property and gather evidence, but you can use photographs and anything you've observed and statutory declarations and that sort of thing. I'll take you through this a lot more in the next webinar. The big issue is costs. If you lose, you can have to pay the other side's costs. So there are ways around that. You can get a costs order to protect you. And you can also, the court might find that your case is in the public interest and decide not to award costs if you lose. We're really good at advising people on that sort of thing. So it's just to let you know that governments can really be disappointing at enforcement, even if you can show them that, you know, something unlawful has happened. They might not investigate, they might not have the resources, but in community groups and individuals can take this action. So it's just something to be aware of if things get desperate. Next slide. The QR code will take you to our evaluation form that the EDO uses. I've never presented this before, love feedback, but I'm happy to answer any questions. Danielle, you're on mute.
Oh yeah,
Yeah.
Jem, that was fantastic. It was very depressing as well to realize how weak I guess our biodiversity laws are, thinking that a koala credit is really the life of a koala, which is quite terrifying. But it's great that there's so many people here who are interested in the legal system. So we have a few questions. I'm mindful of the time, so maybe I'll ask just a couple that people have listed here. Ian McKenzie has asked, what obligation does the Commonwealth have in ensuring that Australia, including all of its states and territories, comply with the Glasgow COP26 Leaders Declaration to halt and reverse forest loss and land degradation by 2030? How can this be used in campaigns to halt forest clearing and degradation?
Well, the general principle with international agreements is that in Australia, we can ratify or sign the agreement, sign ourselves up to it, but unless we've enacted it into domestic legislation, then the government's not accountable. So they might be broadly accountable to the international community and put under pressure and encouraged and cajoled and, you know, all of those diplomacy strategies that other countries use, but we have no legal, we have to have it implemented into domestic legislation before it can really be useful here. So that's what the EPBC Act does, not the agreement that you're talking about, but it implements our international obligations under various treaties, you know, World Heritage Convention, Convention on Biological Diversity, that sort of thing. So we would need to see something like that here.
Fantastic. We have
implemented into domestic legislation, probably the EPBC Act.
Fantastic. It's fantastic. We have so many questions. Another question here in the chat was, how do we get no net loss back into environmental law?
Yeah, that was a standard that we lost. So no net loss, or yeah, what is another one? Neutral or beneficial impact. There's some good tests. They're legal standards. Look, it's been there, so, or you could, once you've had it in the law, it's probably easier to get it back. I don't know why I do know why they probably dropped it. Having legal standards is problematic if you don't want to abide by them. You just have to ask them to put it back in.
Yeah, we need to advocate.
Yeah, and think about look at justify it by saying, well, what did we achieve when we had, you know, a no net loss standard, and how have things changed since we got rid of it? And wouldn't it be better if we had it back again? Was it really the thing that made a difference?
Fantastic. And somebody's asked, do you have more info on the clearing codes on your website?
Yes, the clearing codes, well, they're published on the New South Wales legislation website. They're a regulation. So if you go to New South Wales legislation, it says Acts, regulations. So it's a reg, and it would be under N for native vegetation.
Fantastic.
Yeah, clearing codes, or they're called the codes. There's 5 or 6 codes in one big document, but essentially they're a reg, and yeah, they specify all the little rules that apply to rural land clearing.
Wonderful. And how does an AOBV declaration affect an area that is already reserved under the NPWS Act, e.g. Mount Canobolas?
Canobolas, yeah,
Yes.
that's where there's that BMX bike track is proposed. Look, it probably, I don't know that it would add a lot. I'd have to take that question on notice. But we don't deal with AOBVs because they're not really around too much. If it's private land, the minister needs to try and enter a private conservation agreement. If it's on public land, it would trigger the need for offsetting, because when they're looking at when they're looking at applying the 5-part test, they'd come up against, they'd say, oh, is it on an AOBV? Yes, it is. Oh, I now need to do a VDAR and I'll need to offset the impacts of my development on the AOBV. So it doesn't stop development. It's not locking anything up, but it will definitely trigger the offsetting scheme. Other than that, it would probably be an additional thing to consider for the minister or the decision maker, and they might want to think, okay, is it really in the public interest to be approving a development in an AOBV, because it's been declared that for a reason. Yeah, but as you probably already know, with Mount Canobolas, it's already a state conservation area or something, and it's getting a bike track. And it's the same with the Illawarra escarpment. There's another bike track, BMX track proposed there, and that through a state conservation area. They don't necessarily stop development. They just, yeah, they can still be approved.
And is there a required time period for an AOBV nomination to be decided?
There may be a statutory time frame, but I don't know what it would be off the top of my head. I suspect there's not. I suspect it can just sit on the minister's desk for quite a while and they can get to it.
And do you think the EPBC Act can be altered to allow the feds to become more involved in state land use decisions, at least the larger ones? Do you think this is a possibility?
Altered, well, they can be quite involved in state land use. I don't know what that, I mean, state decision making, state land use.
I guess, John Benson, I think, who asked the question, I'm assuming that maybe are you concerned with issues to do with land clearing? Is this the issue with large scale land clearing?
If it's land clearing, it can trigger the EPBC Act already if it's going to impact threatened species or ecological communities. But no, they very rarely get referred and they very rarely get reported. Like, you know, civil society doesn't tend to get involved enough in those big land clearing decisions, although we have referred matters or tried, you know, asked the minister to call them in. And they have been refused on the grounds of unacceptable impacts.
And Nigel Waters has asked, what's the track record in the actual use of criteria for NES for MINS?
Matters of national environmental significance.
Yeah.
What's the track record on the? What's the question again?
They're assuming that I guess because there's such a high level of referrals, and obviously they can't get around to everything. So what's the track record? I guess they're wondering, you know, is there any point raising I guess a listing or a concern under the EPBC Act? Maybe they're trying to find out what are the chances of their request.
I don't want to tell you something that's going to demoralize you. I mean, look, so matters of national environmental significance, they trigger the act, and then the minister decides whether or not it's a controlled action, and it has to be a controlled action before she has any decision-making power, right? If she does, then she gets to either approve it or refuse it. Of the thousands upon thousands of projects and developments that have been referred to the minister held to be controlled actions, so they're going to have a significant impact. I reckon a handful have been refused. Like, it is really bad. They get approved though, subject to conditions. Now, this is probably of small consolation because the federal government's no better at enforcing its approvals than state governments are. But those conditions can be used by civil society to hold the proponent to account. So you've got your civil enforcement, and I know that's a long shot as well. Like, none of these are easy answers. So to summarize, it's probably going to get approved realistically, no matter what. But this minister, will see how she goes. She's already talking about refusing Clive Palmer's coal mine because of its impacts on the Great Barrier Reef. So, you know, that's a start, and that would be a first. And then, yeah, it would just be a matter of they tend to just add additional conditions that they then don't enforce, but they could enforce, and civil society can enforce. So 17 out of 6,000 referrals, yeah. So
wow.
2 handfuls. 2 handfuls have been refused. Like, it's just like, look, those statistics are appalling. Yeah.
It's crazy. I feel like we could continue on with these conversations, all night. You're just a fountain of knowledge. Thank you so much, Jem, for presenting tonight. There are so many questions here that have gone unanswered. However, no, that's all right, because we're so lucky to have you again in a couple of weeks. So everyone, please sign on to the next workshop with Jem. She'll be digging into the whole submission process and helping us to become expert submission writers. And we might have to invite you again for a 3rd time at some point in the future, because there are just so many questions here.
I can see people in the chat answering each other's questions as well, which is so awesome.
Oh, it's fantastic.
It's great. And yeah, so thanks for having me. I really appreciate the opportunity to talk to you. Sorry, it's not better news.
And we'll make sure that we send your presentation around to everyone. And we'll also make sure that we post it online on the NPA YouTube channel. It just might take us a few days just because we're having a few technical problems on our end, but we promise we will get it up there. So thank you again for everyone for attending tonight. And yeah, Jem, until we meet again in a couple of weeks. Thank you.
Thank you. See you all later.
Bye, everyone. Thank you.